Reading out of the Criminal Procedure Book, Chapter 3, Arrest, Search, and Seizure. Part 4, Search Warrants. As the cases in the 3 sections following this one illustrate, there are many instances in which the police may seize and search on probable cause without first obtaining a warrant. However, the obtaining and executing of search warrants is nonetheless a common means for obtaining evidence of crime. For with rare exceptions, extended searches of premises may be conducted only pursuant to a warrant. The Fourth Amendment sets out several requirements for warrants, stating that no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So I'm going to mark that particular quote from the Constitution. And the last paragraph in the introductory section of search warrants is the first case in this section. Maryland v. Garrison considers the meaning and significance of the particular description requirement. Garrison, together with the other case included here, Richards v. Wisconsin, also explores what it takes for the execution of a valid search warrant to be reasonable. Still another requirement under the Fourth Amendment. So, Maryland v. Garrison was heard in 1987. Justice Stevens delivered the opinion of the court. Baltimore officers obtained and executed a warrant to search the person of Lawrence McWebb and the premises known as 2036 Park Avenue, 3rd floor apartment when the police applied for the warrant, and when they conducted the search warrant, or pursuant to the warrant, they reasonably believed that there was only one apartment on the premises described in the warrant. In fact, the 3rd floor was divided into 2 apartments, one occupied by McWebb and one by Respondent Garrison. Before the officers executed the warrant, became aware that they were in a separate apartment occupied by Respondent. They had discovered the contraband that provided the basis for Respondent's conviction for violating Maryland's Controlled Substance Act. The question presented is whether the seizure of that contraband was prohibited by the Fourth Amendment. The trial court denied a motion to suppress the evidence seized from his apartment, and the Maryland Court of Special Appeals affirmed. The Court of Appeals in Maryland reversed and remanded with instructions to remand the case for a new trial. There's no question that the warrant was valid and that it was supported by probable cause. The trial court found, and the 2 appellate courts did not dispute, that after making a reasonable investigation, including a verification of information obtained from a reliable informant and exterior examination of the 3-story building at 1036 Park Avenue and an inquiry of the utility company, the officer who obtained the warrant reasonably concluded that there was only one apartment on the 3rd floor and that it was occupied by McWebb. When 6 Baltimore police officers executed the warrant, they fortuitously encountered McWebb in front of the building and used his key to gain admittance to the 1st floor hallway and to the locked door at the top of the stairs to the 3rd floor. As they entered the vestibule on the 3rd floor, they encountered Respondent, who was standing in the hallway area. The police could see into the interior of both McWebb's apartment to the left and Respondent's to the right, for the doors to both were open. Only after Respondent's apartment had been entered and heroin, cash, and drug paraphernalia had been found did any of the officers realize that the 3rd floor contained 2 apartments. As soon as they became aware of the fact, the search was discontinued. All of the officers reasonably believed that they were searching McWebb's apartment. No further search of Respondent's apartment was made. With the conclusion of all 3 Maryland courts that the warrant, insofar as it authorized a search that turned out to be ambiguous in scope, was invalid when it was valid when it was issued. So it turned out to be ambiguous, but it was valid when it was issued. The question whether the execution of the warrant violated respondent's constitutional right to be secure in his home is somewhat less clear. New question. We have no difficulty concluding that the officer's entry into the third floor common area was legal. They carried a warrant for those premises, and they were accompanied by McWebb, who provided the key that they used to open the door, giving access to the third floor common area. If the officers had known or should have known that the third floor contained 2 apartments before they entered the living quarters on the third floor, and thus had been aware of the error of the warrant, they would have been obligated to limit their search to McWebb's apartment. Moreover, as the officers recognized, they were required to discontinue the search of respondent's apartment as soon as they discovered that there were 2 separate units on the third floor, and therefore were put on notice of the risk that they might be in a unit erroneously included within the terms of the warrant. The officers' conduct and the limits of the search were based on the information available as the search proceeded. While the purposes justifying the police search strictly limit the permissible extent of the search, the court has also recognized the need to allow some latitude for honest mistakes and that are made by officers in the dangerous and difficult process of making arrests and executing search warrants. In Hill v. California of 1971, we consider the validity of the arrest of a man named Miller based on the mistaken belief that he was Hill. The police had probable cause to arrest Hill, and they, in good faith, believed that Miller was Hill when they found him in Hill's apartment. As we explained, the upshot was that the officers in good faith believed Miller was Hill and arrested him. They were quite wrong, as it turned out, and subjective good faith belief would not in itself justify either the arrest or the subsequent search. But sufficient probability, not certainty, is the touchstone of reasonableness under the Fourth Amendment, and on the record before us, the officer's mistake was understandable, and the arrest a reasonable response to the situation facing them at the time. While Hill involved an arrest without a warrant, its underlying rationale that an officer's reasonable misidentification of a person does not invalidate a valid arrest is equally applicable to an officer's reasonable failure to appreciate that the valid warrant describes too broadly the premises to be searched. Under the reasoning in Hill, so that's the Hill reasoning. The validity of the search of a resident's apartment pursuant to a warrant authorizing the search of the entire third floor depends on whether the officer's failure to realize the overbreadth of the warrant was objectively understandable and reasonable. Here, it unquestionably was. The objective facts available to the officers at the time suggested no distinction between McWebb's apartment and the third floor premises. For that reason, the officers properly responded to the command containing a valid warrant, even if the warrant is interpreted as authorizing a search limited to McWebb's apartment rather than the entire third floor. Prior to the officers' discovery of the factual mistake, they perceived McWebb's apartment and the third floor premises as one and the same. Therefore, their execution of the warrant reasonably included the entire third floor. Under either interpretation of the warrant, the officers' conduct was consistent with a reasonable effort to ascertain and identify the place intended to be searched within the meaning of the Fourth Amendment. The judgment of the Court of Appeals is reversed, and the case is remanded for further proceedings not consistent with this opinion. It is so ordered. So Justice Blackmun, with whom Justice Brennan and Marshall joined dissenting. Interested to see if there's not any concurrence. And this is short, so no, it's not short. Kidding. But it's the only thing we've got. It's just this dissent. I conclude that the search of respondent's apartment was improper. The words of the warrant were plain and distinctive. The warrant directed the officers to seize marijuana and drug paraphernalia on the person of McWebb and in McWebb's apartment, i.e. on the premises known as 1036 Park Avenue, 3rd floor apartment. As the Court of Appeals observed, the warrant specifically authorized a search of only McWebb's, not respondent's residence. In its interpretation of the warrant, the majority suggests that the language of this document, as well as that in the supporting affidavit, permitted a search of the entire 3rd floor. It escapes me why the language in this question, 3rd floor apartment, when used with reference to a single unit in a multiple occupancy building and in the context of one person's residence, plainly was the meaning of majority discerns, rather than its apparent and indeed obvious signification, one apartment located on the 3rd floor. Accordingly, if, as appears to be the case, the warrant was limited in its description to the 3rd floor apartment of McWebb, then the search of the additional apartment respondents was warrantless and is presumed unreasonable in the absence of some one of a number of well-defined exigent circumstances. Because the state has not advanced any such exception to the warrant requirement, the evidence obtained as a result of the search should have been excluded. Even if one accepts the majority's view that there is no Fourth Amendment violation where officers' mistake is reasonable, it is questionable whether the standard is met in this case. The efforts of Detective Marcus, the officer who procured the search warrant, did not meet the standard of reasonableness, particularly considering that the detective knew the search concerned a unit of a multiple occupancy building. Upon learning from his informant that McWebb was selling marijuana in his 3rd floor apartment, Marcus inspected the outside of the building. He did not approach it, however, to gather information about the configuration of the apartments. Had he done so, he would have discovered, as did another officer on the day of executing the warrant, that there were 7 separate mailboxes and bells on the porch outside the main entrance to the house. Although there is some dispute over whether names were affixed near these boxes and bells, their existence alone puts a reasonable observer on notice that the 3-story structure with possibly a basement had 7 individual units. The detective, therefore, should have been aware that further investigation was necessary to eliminate the possibility of more than one unit being located on the 3rd floor. Moreover, when Detective Marcus's informant told him that he had purchased drugs in McWebb's apartment, it appears that the detective never thought to ask the informant whether McWebb's apartment was the only one on the 3rd floor. These efforts, which would have placed slight burden on the detective, are necessary in order to render reasonable the officer's behavior in seeking a warrant. Moreover, even if one believed that Marcus's efforts in providing information for issuance of the warrant were reasonable, I doubt whether the officer's execution of the warrant would meet such a standard. In the court's view, the objective facts did put the officers on notice that they were dealing with 2 separate apartments on the 3rd floor until the moment considerably into the search after they had rummaged through a dresser and a closet in Respondent's apartment and had discovered evidence incriminating him when they realized their mistake. The court appears to base its conclusion that the officer's error here was reasonable on the fact that neither McWebb nor Respondent ever told the officers during the search that they lived in separate apartments. In my view, however, the objective facts should have made the officers aware that there were 2 different apartments on the 3rd floor, well before they discovered the incriminating evidence in Respondent's apartment. Before McWebb happened to drive up while the search party was preparing to execute the warrant, one of the officers, Detective Shee, somewhat disguised as a construction worker, was already on the porch of the row house and was seeking to gain access to the locked 1st floor door of that permitted entrance into the building. From this vantage point, he had time to observe the 7 mailboxes and bells. Indeed, he rang all 7 bells, apparently in an effort to summon some resident to open the front door to the search party. A reasonable officer in Detective Shee's position, already aware that this was a multi-unit building and now armed with further knowledge of the number of units in the structure, could have conducted at the time more investigation to specify the exact location of McWebb's apartment before proceeding further. For example, he might have questioned another resident of the building. Moreover, a reasonable officer would have realized the mistake in the warrant during the moments following the officer's entrance to the third floor. The officers gained access to the vestibule separating McWebb's and respondent's apartments through a locked door for which McWebb supplied the key. There, in the open doorway to his apartment, they encountered respondent clad in pajamas and wearing a half-body cast as a result of a recent spinal operation. Although the facts concerning what next occurred are somewhat in dispute, it appears that respondent, together with McWebb's and the passenger from McWebb's car, were shepherded into McWebb's apartment across the vestibule from his own. Once again, the officers were curiously silent. The informant had not led the officers to believe that anyone other than McWebb lived in the third-floor apartment. The search party had McWebb, the person targeted by the search warrant, in custody when it gained access to the vestibule, yet when they met respondent on the third floor, they simply asked him who he was, but never where he lived. Had they done so, it was likely they would have discovered the mistake in the warrant before they began their search. Finally, most importantly, even if the officers had learned nothing from respondent, they should have realized the error in the warrant from their initial security sweep. Once on the third floor, the officers first fanned out through the rooms to conduct a preliminary check for other occupants who might pose a danger to them. As the map of the third floor demonstrates, the two apartments were almost a mirror image of each other. Each had a bathroom, a kitchen, a living room, a bedroom. Given the somewhat symmetrical layout of the apartments, it is difficult to imagine that in the initial security sweep, a reasonable officer would not have discerned that the two apartments were on the third floor, realizing his mistake, and then confined the ensuing search to McWebb's residence. Accordingly, even if a reasonable error on the part of the police officers prevents the Fourth Amendment violation, the mistakes here, both with respect to obtaining the and executing the warrant, are not reasonable and could easily have been avoided. I respectfully dissent.